2022. Sri Kiran Kumar, Learned Government Advocate, seeks 2 days time to comply the order. Guruvara. ಇವತ್ತು ಮಂಗಳವಾರ ಬುಧವಾರ ಗುರುವಾರ ಯಾವ್ದು ಬೇಕು 6 time till Friday. Call the matter Friday for compliance. Even if he complies, there is a still delay. The concerned accused has to pay the cost. Yes, Manjunath.
Complained by me, my lord. My lord, ink page number 18, my lord, wherein the Honorable Trial Court directed the defendant to deposit the amount of rupees 38 lakhs towards the arrears of rent, my lord. That is not completed by the accused, my lord. I will comply the office objection within 1 week, my lord.
First comply.
Yes,
1 week that comply office objection. Yes. You are already there. Correct. Government advocate, finally 1 week time is allotted for compliance of the order. Yanapa, Anand Barley, no 1 week, no 2 weeks. Sister, wait, you are not passed the order. You can tell at the time of final hearing, you will calculate and give it to you, don't worry. Sir, then you have to pay 2,000 rupees cost every day. All right. The Council for the System Compliance, along with the cost imposed 2,000 per day, 2 weeks. We will calculate and recover. I'll order the quarterly. Then, Namu Sambandha illa, sir. Time for compliance 4 months from the date of copy order failing which second or from deputy commissioner shall personally pay cost of rupees 2,000 per day. ನಾವೆಲ್ಲ ಲಕ್ಕ ಹಾಕ್ತಿವಿ ಅದು ಅವ್ರು ಸಾಯ್ಬಾರ್ದು ಪರ್ ಡೇ 2,000 ಮತ್ತೆ ಕಾಸ್ಟ್ ಬೇರೆ ನಮ್ದು ರಿಟ್ ಹಾಕಿ ನಮ್ ಸಂಬಂಧ ಇಲ್ಲ ರಿಟ್ ಏನಾಗಿದೆ ಸ್ವಲ್ಪ ಇದಮ್ಮ you apply lit petition. Wait, for not paying cost. Oh, shorten the time. Wow, wonderful litigant. 3 months beda anta. Oh, you are a litigating mind. 4 months beda anta 1 ತಿಂಗಳಲ್ಲಿ ಮಾಡಬೇಕು ಅಂತನಾ? 4 months time granted. You are appeal dismiss. No. Your appeal is dismissed. That's all. You are not implementing order. Implementing only only concentrate that. Yes. 2 weeks ada ಹೇಳಿದವಲ್ಲ ಆಮೇಲೆ ಕಾಸ್ಟ್ ಆಗ್ತಾನೆ can't help it sir. ಎಲ್ಲರಿಗೂ ಒಂದೇ ನ್ಯಾಯ. Justice to all. ಅವ್ರು ತಪ್ಪು ಮಾಡಿದ್ರೆ ಅವ್ರು ವಜಾ ಮಾಡಿ ಅವ್ರು ಕಾಸ್ಟ್ ಹಾಕ್ತಿವಿ ಸುಳ್ಳು ಹೇಳಿದ್ರೆ ಸುಳ್ಳು ಕಾನ್ಫಿಡೆಂಟ್ ಹಾಕಿದ್ರೆ ಎಸ್ ಎಸ್
I am to respond in the connected matters.
Yes. Adiyar mata kodi. What is the order? Single judge order. ಇವತ್ತಾರ್ಕೆ ಮಾಡಿದ್ನ ಫಿಕ್ಸ್ ಡೇಟ್. No sir, you are not cooperating with court. Date fix ಮಾಡಿ 2012 2018 ಇವತ್ತ ಡೇಟ್ ಫಿಕ್ಸ್ ಬಿಗ್ನರಿಂಗ್. No, don't worry. You argue. If you make out a case, admit. Otherwise, dismiss. That's all. Argue. It is the input order. Is it so? Oh, Mr. Ola. Main appeal admitted. Which is that appeal? 4 bar. This is against the same order. Against which order? Yes, sir. If already admitted, admit this matter. What's the matter by that's all.
Lord, my matter 1202 is a different order, my lord. That is not same as that. You may have to make out a case.
Yes, so.
Main order is that in the written is go by that challenge. The order is relying on other entities.
Yes, our Sridhar Prabhu ಅದಲ್ವಾ?
ಅದಲ್ಲ ಸರ್, ಅದು 24th October 2011 order, my lord. Issue may be same, the order is different, my lord.
ನೀವು ಆರ್ಗ್ಯೂ ಮಾಡಿಪ್ಪ, ಮುಗಿಸ್ಬಿಡ್ತೀನಿ. The counsel for the appellant is not ready. ಯಾವತ್ತು ಬೇಕು?
In the meantime, my lord, I pray that there was a direction to the government to file an affidavit. Let them file the affidavit, my lord. I am praying. Lordships may see
Yes,
the cost title. Affidavit.
Government, who pays the government? Why of the affidavit? They already filed.
That was, we have not
ಕಾಪಿ
received.
ಕೊಡಿ ಒಂದು.
ಆಯ್ತು.
My lord, say 31.5 also, my lord.
Yes, yes. Yes, Vijay. Now, what is the violation, sir? ಎಲ್ಲಿದೆ? ಅದು ಬಂದಿದೆ. ಜನರಲ್ ಗ್ರಾಂಟ್ Yes. Read that. Yes. What happened? It appeals.
My lord, appearing for complainant in serial number 34, my lord. My lord, the respondent herein has not complied with the order passed by this honorable court, my lord. The order passed by this honorable court is at Annexure A, my lord. My lord, the honorable court has directed the respondents to conduct the Durasti and Podi within 6 months from the date of receipt of the order, my lord.
Madam, notice is
So-
ordered, madam.
Notice is
Please,
issued.
Please, my lord.
Fine.
My lord, in serial number 35, appearing for complaining, my lord. My lord, the accused herein had filed had obtained a divorce, my lord, in from family court. Against the said divorce, the complainant herein had filed the MFA number 3873 of 2019 before this honorable court, my lord.
Yes.
In this MFA, my lord, the complainant had also asked for an interim maintenance of 25,000, and the honorable court had already granted the 25,000, my lord. My lord, since from the date of application, the accused ought to have given the maintenance, my lord, but until now he has not paid the maintenance, my lord.
See, this is a case where you or the other counsel was unable to give any satisfactory income.
Please, my lord.
That's where we refer. Now, on doctor ಅಂತ ಹೇಳಿ ಕೊಟ್ಟಿದ್ದೀವಿ 25,000. Unfortunately, the present case, learned counsel of both the parties not in a position to assist the court. Therefore, the court finds difficulty to interpret the income of the respondent. The conduct both the counsel is nothing but obstructing the court proceedings, abusing the process of law. All right, issue notice.
My lord, one submission, my lord. My lord, in MFA 3873, Kiran Rosaria was handling the matter, my lord. Your lordship may direct notice to the same person, same advocate.
Issue notice, no question of Kiran Rosaria. Yes, sir.
Please, ma'am.
Also, madam. Number 12.
Yes, Mr.
Lorships.
There's no such idea here.
There is no such idea. My lords have dismissed that NIS.
Yes, madam. Perform ಮಾಡ್ರಿ. Ready? Court is waiting for you. I'm sorry. Responsibility. ಬರ್ಲಿದ್ದಾಳಲ್ಲ ಹುಡುಗಿ ಯಾವಾಗ್ಲೂ ಹಂಗೆ ಎಲ್ಲ ಅವನು ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಇಂಟ್ಯಾಕ್ಟ್ ಮಾಡಕ್ ಹೋಗ್ತಾಳೆ ಎಲ್ಲ ಸುಳ್ಳು ಹೇಳ್ತಾಳೆ ಆ ಮಾಡ್ತಾಳೆ. ಒಂದೆರಡು ನಿಮಿಷ ವೇಟ್ ಮಾಡಿ. ಇಲ್ಲ ಏನಿಲ್ಲ. ಎಸ್.
Order number 1, Duty Mallikarjuna.
Yes, Mallikarjun. A2 2021 business was not present. Yes. Yes, I learned about it. Yes. Yes, Srirangaya.
My lordship. My lordship, I am for appellant. My lordship, I came for suspicion of sentence of the appellant number 1, Your Honor. My lordship. My lordship, already the appellant number 3 enlarged on bail, my lordship. That is appellant number 3 already enlarged. The appellant number 1 has spent more than 6 years, 4 months to 16 days in prison, my lordship.
That is not a ground.
My lordship, so many regulators are there. His parents is old age. The appellant number 1 has having old age parents, my lordship. There is no one to.
Sir, already accused number 1 application rejected by this court earlier.
Withdrawn, my lordship. Appellant number 1 and 2 application withdrawn and 3 only pressed. Same my lordship.
No withdrawn.
My lordship, I beg for withdrawing the.
Number 3.
My lordship.
Only against suspect 3 rejected. Others not withdrawn. Withdrawn.
My lordship, I prayed for withdrawn at that time, my lordship.
We don't know.
My lordship.
You got to renew the prayer. Other than I said. Yes.
My
What's the
lordship.
ground?
My lordship, the appellant has a minor daughter, my lordship. No one to care for them. They are also suffering from COVID-19.
2017, you are not pressing. And you are
No.
pressing 22.
No, my lordship, the parents.
2017, nobody was there.
No, my lordship, no one communicated me since the date because they are residing in abroad area of the Pavagada Taluk, my lordship. When they are communicating me, then I have filed this application, my lordship.
All right. What is the point?
My lordship, he has minor daughter, my lordship. No, the mother is also not there.
Every accused have a minor girl and parents.
No, my lordship. His first wife already died. First wife daughter is minor daughter is there, my lordship. Until disposal of this appeal, may kindly listen because of the care.
Mr. Mere you have a minor daughter for second wife is not a ground for granting suspension. What is the ground?
My lordship, he has been already spent more than 6.5 years in prison, my lordship.
That is on merits. That is on merits.
My lordship, the charges. My lordship, the charges also not framed properly. The points for consideration and so many irregularities.
Mister, that will be a matter of arguments, not IA. You are arguing on merits. Merits is not concerned. The IA 1. What is the case on against you?
Please,
You are involved in 302.
Please, my lordship.
Who are you? You are the husband.
Please, my lordship. Devan is the husband of the my lordship.
Who is the deceased?
Of the appellant number 3, my lordship. But he's not defending him, my lordship. The totally the.
So what is the punishment for Sharda? Allari, she is having illicit relation with the disease. On punishment to death, you will get no. Now, life. What is the punishment given by husband? I am out of the How can he support such a wife? Who is accused number 2?
Brother of the appellant number 1, my lordship.
Now accused 1 and 3, 2 and 3. 3 only now granted bail.
Please, my lordship. 1 and 2 in
The wife
the.
is there to take care of minor, don't worry.
No, my lordship, she is second wife. She has already eloped with someone.
All right. Wonderful. Pick part, Tata. Your size is lot of lost. That's all. We are rejecting your fiction, sir.
Please, my lordship.
Mama.
In the interest of aged guardian parents and.
You argue the matter, mister. You argue the matter, main matter itself. Not you can't file now the application after 2022. Baba. So the present accused filed earlier application, IA1 2017. We did not press to the said application as long back as on 13/2/2027. Our liberty reserved to renew the prior as and when necessary. Thereby, the present application is filed on 11/1/2022 for suspension under the application section 389, read with section 482 criminal procedure for suspension of sentence and release on bail. It is contained in the application that the appellant has a minor daughter and she has completed secondary school or education and future is suffered if the appellant is not released on bail. She has no mother. The appellant number 1 age mother, father are dependent on the appellant number 1. Entire family members suffered by the livelihood. First of the accused has got very good case on merits. If he has kept in judicial custody, the family members will put to great hardship and injustice. And he was further contended that throughout the penance of the trial was on bail and has not violated any terms and conditions of the bail granted. He would further contended that the appellant is the only appellant's
Only one appellant, one, my lordship.
bread earner in the family. If the appellant is continuing in judicial custody, his family members virtually thrown on streets. Thereby, he sought to suspension application. Stop. The state has not filed any objections. Earlier did not press the law. Not filed any fresh application. But the shown to the government advocate submits that he already filed earlier objections to the earlier application, though not pressed by the accused 1 and 2. The same is adopted to the present application. First up, it is contended in the objections filed previously that the main circumstances were laid upon for the motive to elicit intimacy between accused number 3 and the deceased, and in spite of warning, the deceased continued intimacy with the accused number 3. Last being together seen on the basis of the frequent phone calls between the accused number 2 and deceased. Accused number 3 is accused number 3 and the deceased. Last, the accused 1, 2 were seized for blood stained human blood. Thereby, recovery telephonic calls of the abscondence have been proved by the prosecution. The evidence of the witnesses PW8, PW7, 8, 9, 10, 11, 12. With regard to motive and exhibit 14, 15, 16, with regard to bloodstain found on the class of the accused corroborated by the FSL report, exhibit 46. Telephonic conversation, accused number 3 and the deceased through exhibit 41, 42, and 43. Thereby, the trial court rightly convicted, therefore sought to reject the application. First, we have heard the learned counsel for the parties list. Sri so-and-so learned counsel, Srirangaya, learned counsel for the accused number 1. Reiterating the arguments when the ground urging the memorandum of appeal, as well as the arguments when the application contended that the applicant is the only bread earner in the family and he has a minor daughter who completed secondary school or education. Future is suffered if the applicant is not released on bail. Absolutely, there is no case out by the prosecution against the accused number 1. The and he was in bail throughout the independence of the and material documents exhibit P1 to part 7. Material objects MO 1 to 8 clearly depicts the involvement of the accused number 1 in the homicide death of the deceased. It would further contended that it is the main case of the defense that the accused number 3 and deceased had illicit relationship. Thereby, the accused 1, 2 hatched a plan along with the accused number 3 and killed the deceased. The same is evident from the material documents, material evidence on record. So we would further attend that PW3, 8, 9, 10, 11, 12 was stated on oath about the motive for murder. Yes, other content exhibit 14, 15, 16. Bloodstain articles are corroborated with the FSL report exhibit 46. Therefore, he sought to dismiss the application. Next paragraph. Having heard the learned counsel for the parties, come on, the undisputed fact that the learned session judge, considering both oral and document evidence on record, recorded a finding that the prosecution proved beyond reasonable doubt accused number 3 was having illegitimate relationship with the deceased, and the accused of cause death of the deceased, and the accused persons caused the death intentionally with knowledge, thereby committed offense pursuant to 302 IPC. To stop, it is also not in dispute that an earlier application filed before this court was not pressed by the order dated 13/2/2017. From 2017 till today, till 11/1/2022, there was no urgency for the accused. Only in the year 2011/2022, he filed the present application for release on bail, mainly on the ground as a minor daughter, and the entire family member depends on him, depending on his family, depending on the income of the accused. And throughout he was on bail. The fact remains that the material record clearly depicts accused involved homicide death of the deceased. Merely accused number 3, the wife of the accused number 1, released on bail, taking consent is a woman, cannot be a ground to release the accused number 1 in the previous grievous heinous crime committed by the accused 1 to 3 under the provisions of section 302 IPC. Apart from the appropriate material and record, the evidence of material and record placed for prosecution, in particular, the evidence of 7, 8, 9, 10, 11, 12, with regard to motive. And 14, exhibit 14, 15, 16, Lestein found on the class of the accused, corroborated by a special report, exhibit 46, and telephonic conversation between accused number 3 and the deceased, exhibit 41, 42, 43. Thereby, the trial court rightly convicted the accused for the offense of 302 IPC. So, it is relevant to consider that the present application is filed after after trial, post conviction. The merely granted the bail before the trial, is not a ground to grant a bail after post conviction, since the learned judge, considering both oral and document evidence on record, has come to conclusion that the accused involves one side of the deceased. Thereby, the accused has not made out any ground to grant any bail at this stage. First of all, the above, the application IA 1 2022 dismissed, divide of merit, rejected, divide of merit. Paper book nodi. ಏನ್ರಿ ಆ ಕೋರ್ಟಲ್ ಆರ್ಡರ್ ಆಗುತ್ತೆ ಈಗ ಹಾಕೋದಿಲ್ಲ ಮಾಡಬೇಕು ಆರ್ಡರ್ ಬೇಕಾಗಿಲ್ಲ though this court as long back as on 6/2/2017 directed registry to file paper books 17, 18, 19, 20, 21. Even after 5 years, the office has not prepared paper books. Shows the office has no respect for the court order. The registry directed to ensure to file paper books as soon as the criminal appeals admitted, and they should not wait for the court direction. The rules of practice. And admitted in the present case, though order of specific order was passed, the office has not complied. The registry directed to take action forthwith against concerned officer and ensure paper books shall be filed within 2 weeks.
I am appearing for the appellant in this case, my lord. I am appearing for accused number 2, appellant 2 in this case. Your lordship,
Yes.
the offense registered against the appellant is section 17 of the POSCO Act, where he was ordered to go imprisonment for 10 years, my lord, at page 120. Your lordship
Yes.
will get in the order at page 120. And also, my lord, section 10 of the Prohibition of Child Marriage Act. My lord, the case is the accused number 1. He, on the pretext of giving book, he has eloped with, he has taken the victim girl and he has committed sexual offense. The offense of
They are appealing
376.
for whom?
And this appellant is only they have assisted marriage. ಇದು ಮದ್ವೆ ಮಾಡಕ್ಕೆ ಸಹಾಯ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಇವ್ರ ಮೇಲೆ ಅಲಿಗೇಷನ್ ಸ್ವಾಮಿ.
ಹೌದು, ಹೆಂಗ್ ಮಾಡ್ತೀರಿ ಮೈನರ್ ಗರ್ಲ್ ನೀವು? How can you assist, madam, minor girl? Your application already rejected. What is the change circumstances?
Change circumstances is, my lord, the appellant number
Only judges change.
4 and my lord, please, my lord.
Only judges change. That is change circumstances.
10 years. My lord, the appellant number 4 and 5 have been enlarged on bail by Supreme. I have produced the copy of the kindly peruse.
All right, go. This also take the Supreme Court. That is not a ground, ma. Allu kottida is not a ground. You make it a case.
They have abated and also abated in.
You are abated for offense of a minor child, attracting provisions of POSCO Act.
And they were on bail during trial, my lord. And if the paper book is filed, I am ready to argue on merits, my lord. I will withdraw. I will withdraw this application, my lord.
After arguing the matter for some time, learned counsel for the accused number 1 and 2 sought to dismiss the application year 2020 dismiss as withdrawn. Office is directed in the paper book ಎಲ್ಲ ಕೊಡ್ಕೊಂತಿದ್ದಾರೆ. ಏನ್ ಮಾಡ್ಬೇಕ್ರಿ ನಿಮ್ಮವ್ರು ಪೇಪರ್ ಬುಕ್ ಹಾಕೋದು ಹೇಳಿದ್ರಲ್ಲ ಏನು ಮಾಡೋದಿಲ್ಲ ಏನ್ ಅಡ್ಮಿಟ್ ಮಾಡಿದ್ದಾರೆ. Admit call for attacks. Office objection, admit. Paper book, no need. Yet another case, though the matter admitted on 21/8/2019, till today the paper book not filed. The office director to prepare paper within a period of 2 weeks. Yes. Raju. ಏನು ಇದು ನಿಮ್ಮ ಮುಂದೆ ಮೊದಲೊಂದ್ಸಲ ಆರ್ಡರ್ ಆಗಿದೆ. Application accordingly rejected. Accused number 3. Accused number appellant number 1. Accused number 3 ನ ಇದು ಎಷ್ಟೆಷ್ಟು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದಾರೆ. ಅಕ್ಯೂಸ್ ನಂಬರ್ 2 ವಜಾ ಆಗಿದೆ. Who appears? None appears. Yes, Subramanya. Yes, Subramanya. ಹೇಳ್ತಾರೆ. That is not a ground. When you have admitted everything in the 313 and the learned judge considering the entire matter and come to conclusion is involved also the death of his own wife. ಹತ್ತು ವರ್ಷ 20 ವರ್ಷ ನಾಟ್ ಅ ಗ್ರೌಂಡ್. ಹೀರಿಂಗ್ ಬಂದಿದೆ, ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ 10 ವರ್ಷ ಅಂತ ಹೇಳೋದು ಅವ್ರು ಹೇಳ್ತಾರೆ ಬೇಲ್ ಕೊಡಕ್ಕೆ ಅಷ್ಟೇ. You make out a case. How is entitled or convict is acquittal? ಅದೇ ರೀ ನಿಮ್ಗೆ ಗಂಡು ಮಗು ಆಗಿಲ್ಲ ಅಂತ ಒಂದೇ ಕಾರಣ ಸಾಯಿಸೋದು.
ಆಮೇಲೆ
Yes. You are displeasure with your wife not giving a male child and gave birth to 2 male children. and the death was due to strangulation, pulling tied dupatta around her neck. That is the evidence, and that is the evidence of doctor also. ಅವರೇ ಒಪ್ಕೊಂಡ್ಬಂದ ಕೋರ್ಟ್ ಮತ್ತೆ ಇನ್ನೇನು ಎವಿಡೆನ್ಸ್ ಬೇಕ್ರಿ 313 ನಲ್ಲಿ. Correct, correct. That cannot be alone. Correct, no problem. We are not asking you that only alone. There are other evidences. How you discharge? How your wife died? Where discharge 106? Our wife died. ನೀವೇನ್ ಹೇಳಿದ್ರಿ? You are with your wife as on the date of death. What do you say? ಹೆಂಗ್ ಸತ್ಲ ಹೆಂಡತಿ? What doctor says? Doctor says what? Then
No difference, sir.
correct, serious agree.
One and the same according to you. Then PM examination, not external examination. Postmortem ಮಾಡೋದೇ ಬಾಡಿ ಮೇಲೆ.
ಪೋಸ್ಟ್ ಮಾರ್ಟಮ್ ಬೇರೆ ಕಡೆ ಮಾಡ್ತಾರಾ? ಎವಿಡೆನ್ಸ್ ಹಾಕ್ಬಿಡಪ್ಪ. ಎವಿಡೆನ್ಸ್ ಹಾಕ್ಬಿಡು 101. ನಿಮ್ಮ ಹೆಂಡತಿ ಹೆಂಗ್ ಸತ್ತರಿ ಅವತ್ತು? ಎಲ್ಲಿ ಹೇಳಿದಿರಿ? Yes, sir. ಎಲ್ಲ ಗೊಂದಲ ಹೊಡ್ತಾರೆ.
ಹೌದು.
ಜನ ಅಧಿಕಾರ ನೋಡ್ಕೊಂಡ್ ಮಾಡ್ತಾರೆ. ಲೀಗಲ್ whatever the circumstances are for suicide, even if assuming suicide, what are the circumstances for suicide? ಸುಮ್ಮನೆ ಜನರಲ್ ಆಗಿ ಹೊಡಿತೀರಾ? ಸೂಸೈಡ್ ರೀ ಅವರು ಸ್ಟ್ರಾಂಗ್ಲೆಸ್ ಅಲ್ಲ ಅಂತ ಕೇಳೋದಲ್ಲ. ಬಂದು ಬಾಂಡ್ ಬಂತಲ್ಲಿ ಮೇಡಮ್ ಅವರು ಕನ್ಫರ್ಮ್ ಇವತ್ತು ಇನ್ನೊಂದು ಬಂದಿರುತ್ತೆ ಚೆಕ್ ಮಾಡು ಕನ್ಫರ್ಮ್ ಮೆಡ್ರಾಸ್ ಇವತ್ತೆಂಟು ಇವತ್ತಲ್ಲ ಇವತ್ತಿರುತ್ತೆ. ಹನ್ನೆರಡು ಸಾವಿರ ಅದು ಕನ್ಫರ್ಮ್ ಆಗುತ್ತೆ. You have succeeded in Supreme Court. The CBI case. ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ರೀ? ಹಾ ಕನ್ಫರ್ಮ್. ಮಗಳ ಬಂದು ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ತಾಳಲ್ಲ. She is the feet of sixth eyewitness. ಅಷ್ಟನಾ? ಏನಕ್ಕೆ ಗೊತ್ತಿರ್ರಿ? ಎಕ್ಸಾಮಿನೇಷನ್ ಒಂದಕ್ಕೊಂದು ಯಾವ್ದು ಟ್ಯಾಲಿ ಆಗ್ತಾ ಇಲ್ಲ. ಸುಮ್ಮನೆ ಅವ್ರ ಕಾಟಾಚಾರಕ್ಕೆ ಹೇಳ್ರಿ ಅದು ಸ್ಟ್ರಾಂಗ್ಲೇಷನ್ ಅಲ್ಲ ಸುಯಿಸೈಡ್ ಅಂತ ಎಕ್ಸಾಮ್ ಮಾಡೋದು. ಅವ್ರು ಇಲ್ಲ ಅಂತ ಅಷ್ಟೇ ಅಲ್ಲಿಗೆ ಬಿಟ್ಬಿಟ್ರು. ಅದೇ ಗ್ರೌಂಡ್ ನಾನು ಸುಬ್ರಹ್ಮಣ್ಯ ಆರ್ಗ್ಯುಮೆಂಟ್ ನಾವೇನ್ ಮಾಡೋದು? ಹತ್ತು ವರ್ಷ ಇದ್ದಾರೆ ಅಷ್ಟೇ. ಏನು ನಾವೇ ಇಲ್ಲ ಅದೆಲ್ಲ ಇಲ್ಲ ನಮ್ಗೆ ಅಂತ ಆಚಾರ ಬರೆಯಕದಲ್ಲ ಅದೆಲ್ಲ ನಾವ್ ಬರೆಯಲ್ಲ ರೀ. ಅಲ್ಲಿ ಬರ್ಕೊ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಾರೆ. ನಾವು ನಮ್ಮ ಕನ್ವಿಕ್ಷನ್ ಆರ್ಡ್ರು ಲೈಫ್ ಕೊಟ್ಟಿದ್ದು ಶಲ್ ನಾಟ್ ಕಮ್ ಇನ್ ದ ಸ್ಟೇಟ್ ಗವರ್ನಮೆಂಟ್ ರೆಮಿಷನ್ ನಾವ್ಯಾಕೆ ಬರೀಬೇಕು? ದಟ್ ಇಸ್ ಡಿಸ್ಕಷನ್ ಆಫ್ ದಿ ಸ್ಟೇಟ್. ನೋ ಸರ್, ದಟ್ ಈಸ್ ಇಮ್ಮೆಟೀರಿಯಲ್ ಫಾರ್ ಅಸ್. ಅದು ಸಪರೇಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸು. ಅದೊಂದು ಎಲ್ಲೋ ಕೆಲವರು ನಿಮ್ಗೆ ಇದಿದೆ. ಅಕ್ಯೂಟರ್ ಮಾಡಕ್ಕೆ ಏನೋ ಪಾಯಿಂಟ್ ಹೇಳಿ. ರೆಮಿಷನ್ ಮತ್ತೆ ಗವರ್ನರ್ ಬರ್ಬೇಕು, ಈ CM ಚೇಂಜ್ ಆಗ್ಬೇಕು, ಅವೆಲ್ಲ ನಮ್ಗೆ ಸಂಬಂಧ ಇಲ್ಲ. ಒಂದು ಪಿಟ್ ಬೇರೆ ಏನೋ ಹೇಳ್ತಿರ್ರಿ, ಜನರಲ್ ಆಗಿ ಹೇಳ್ತೀರಿ, ಕಂಟೆಂಟ್ ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾರ ಹಂಗೆ. Is a ground for remission here? ಆಯ್ತು. Not the one. Just up. Oh, God.
He was aged 7 years at that time. She was with his accused alone in the house. That was the natural conduct. ಅದು ನಂತರ ಅದು ನನ್ನ ತಾಯಿಯನ್ನು ಸಾಯಿಸಿದ ನಂತರ ನನ್ನ ತಂದೆ ಓಡಿ ಹೋದನು, ನಾನು ಮಲಗಿಕೊಂಡೆನು. ಎಸ್, ವೆರಿಫೈಡ್.
Yes, brother. Ready? Mavada doctor. Yes. Hold on, another data. PW previous ಹೇಳಿದವರು ಯಾರು? previous level
daughter.
ಆಯ್ತು. PW6, PW4, PW5, PW1 and PW7. What is the evidence of doctor? ಏನು ಎವಿಡೆನ್ಸ್? ಎಷ್ಟು ಪೇಜ್? Yes. No.
ಸಾಯಿಸಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ.
That's all. BW. Yes. Incident on 22/3/2000. After on 20. Yes. 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 Stop. ಕಸರಮ್ಮ ದೇವರ ಕಾಪಾಡ್ಬೇಕಮ್ಮ, ಯಾರೋ ಬಂದ ಅಮ್ಮ ಇದನ್ನ ಬರ್ತಿರ್ತಾಳೆ, ಬರೀ ಅಯ್ಯಾಗ ನೋಡಕ್ಕಾಗಲ್ಲ. ಅದು ನಿಮ್ಮ ಇವರಿಗೆ ಶಿಕ್ಷಣ ಗೊತ್ತಾಗಲ್ವಾ? ಕಂಟಂಪ್ಟ್ ಕ್ರಿಮಿನಲ್ ಅಥವಾ ಬೀಜರ್ ಮೆಂಚ್ ವಾಸನ ಕೊಟ್ಟ ಪಾಪ ಅವ್ರು ಹೆಂಗಿದ್ ಬರ್ಕೊಂತ 1 hour ಬರೀತೀವಿ ನಾವು. ಏನೇನೋ ಬರಬೇಕು, ಕಷ್ಟ ಆಗತ್ತಾರೆ. ಅವ್ನ ಕರೀದಿದ್ವಿ 1 ನಿಮಿಷ, ಅರ್ಥ ಆಗಲ್ವಾ ಅವ್ನಿಗೆ? ಆ ಹೊಸ ಮಕ್ಕಳನ್ನ ಸಣ್ಣ ಎಂಟ್ರಿ ಮಾಡೋದು, ಅದ್ರ ಸ್ವಲ್ಪ ದಿವಸ ಟ್ರೈನಿಂಗ್ ಅವ್ರು ಕೊಡ್ಬೇಕು. ಏಕ್ದಮ್ ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ಕೊಟ್ರೆ ಅವ್ರು ಏನ್ರ ಬರೀತಾರೆ ಪಾಪ, ಅವ್ರು ಬಿಟ್ಟು ಹೋಗ್ಬೇಕು. ಅವ್ರು ಮಾಡ್ತೀರ, ನಾವು ತಲೆ ಕೆಡ್ಸ್ಕೊಂಡ್ ಬರ್ದಿರ್ತೀವಿ. ಇದಾದ್ರೆ ನಮಗ್ ಬೇಜಾರಾಗುತ್ತೆ, ಬೈದ್ರೆ ಅವ್ರಿಗೆ ಬೇಜಾರಾಗುತ್ತೆ. ಅಂದ್ರೆ ನಾವು ಕೆಲಸ ಮಾಡಬಾರ್ದು ಅಂತ. ಯಾರು ಕರಿ ಅದನ್ನ ನಿಮ್ಮ ದೊರ್ರಾಜ ಸರಿ 1 ನಿಮಿಷ. ಕಷ್ಟ ಎಷ್ಟು ಸರಮ್ಮ? 18 ಗೊತ್ತಾ? ಅಷ್ಟೇ ಧೈರ್ಯ ಜನಗಲ್ಲ ಹೇಳ್ಬೇಕು. ತಪ್ಪುಗಳು ನಮ್ಗೆ ಕಷ್ಟ ಆಗುತ್ತೆ, ಕಷ್ಟಪಟ್ಟು ಬರೀತೀವಿ ನಾವು.
Impugning the judgment of conviction and order of sentence by 2019 has been SC number 963 of 2012 on the file of CH-4 Bengaluru, convicting him for the offence punishable under section 302 of IPC and sentencing to undergo life imprisonment and to pay fine of rupees 10,000, and in default to pay fine to undergo simple imprisonment for 1 year. The facts of the case of the prosecution is that the accused had married the deceased Shivamma about 15 years back, and they were residing together. In their wedlock, 2 daughters were born, but the accused was insisting to beget a son, and he used to ill-treat the deceased both physically and mentally. On 22/3/2012, ill-treating both physically and mentally, only on the reason that the deceased had not given birth to a male child. On 22/3/2012, between 2:30 to 3:30 in the afternoon, the accused picked up quarrel with the deceased in his house and strangulated her neck by pulling the polyester veil tied around her neck. PW1, the brother Ramesh, the brother of the deceased, after coming to know about the causing of the death of the deceased, lodged the first information as per Exhibit P1 on 22/3/2012 itself. After registering the case in crime number 36 of 2012, the investigation was undertaken. After completing the investigation, the charge sheet was came to be filed by the investigating officer against the accused for the offence punishable under section 302 of IPC. After the committal of the matter by the learned magistrate, the learned session judge secured the presence of the accused of registering SC 963 of 2012. The accused pleaded not guilty and claimed to be tried for the offence punishable under section 302 of IPC. The prosecution charge was framed and read over to the accused in the language known to the accused. The accused pleaded not guilty and claimed to be tried. Thereafter, the prosecution examined PWs 1 to 16 got marked exhibit P1 to 12 and identified MOs 1 to 4 in support of its contention. The accused has denied all the incriminating materials and the accused has admitted the incriminating materials available on record in his statement recorded under section 313 of CRPC. As he has not taken any defense nor laid any evidence. The trial court, after taking into consideration all these materials on record, came to the conclusion that the prosecution is successful in proving the guilt of the accused for the offense punishable under section 302 of IPC and passed the impugned judgment of conviction and order of sentence as stated above. Being aggrieved by the same, the accused is before this court, challenging the impugned judgment of conviction and order of sentence, contending that the same is perverse, illegal, arbitrary, and the same is liable to be set aside. The trial court has erred in not appreciating the oral and documentary evidence on record. It has misinterpreted and misread the evidence on record, which has resulted in erroneous conviction and passing of the sentence by the learned sessions judge. It is also contended that the trial court erred in not appreciating that the prosecution has not established the required ingredients of the offense under section 302 of IPC and the guilt of the accused beyond reasonable doubt. The trial court committed an error in convicting the accused only on the basis of the evidence of PWs 4 and 6, who are the child witnesses, and even though they are not the eyewitnesses, the trial court has also relied on the voluntary statement made by the accused, which is not admissible in law. It is also contended that the trial court has given unnecessary importance to the statement of the accused recorded under section 313 of CRPC, which has resulted in miscarriage of justice. The trial court has also erred in holding that the prosecution has discharged its initial burden under section 101 of the Evidence Act and 106 of the Evidence Act. The burden on the accused, which is impermissible under law. The circumstances produced by the prosecution are not sufficient to prove the guilt of the accused, but however, the trial court proceeded to convict the accused without any basis. Hence, the appellant case for allowing the appeal by setting up the impugned judgment of conviction and order of sentence in the interest of justice.
ಬರ್ಕೊಳ್ಳುತ್ತೆ ಐದ ಬರುತ್ತೆ ಇನ್ನು ಬರ್ಕೊಳ್ಳಿ ಐದ ಬರುತ್ತೆ ಅಷ್ಟೇ
Counsel for the appellant. intentional
Apparent counsel.
arguments. Next,
Arguments ಎಲ್ಲ apparent counsel for contra HG.
hence the learned counsel pays for allowing the appeal by setting aside the claim
For
control and additional supporting the judgment of conviction and order of sentence. Contended that the prosecution has placed sufficient material to prove the guilt of accused beyond doubt. If the daughter of the deceased is an eyewitness to the incident, the categorical stated regarding complaints, nothing has been elicited from her during this examination. W1, 4, 5, and 6 are the close relatives of the accused and the deceased, and they have spoken about the motive for causing the murder and the conduct of the accused prior to the commission of the offense. The medical evidence as spoken to by PW7 supports the case of the prosecution. The doctor who conducted postmortem examination issued Exhibit P4, postmortem report, according to which the death was due to asphyxia as a result of strangulation. Even though all these material witnesses are cross-examined at length, nothing has been elicited from them to disbelieve their version. It is not in dispute that the accused and the deceased were in the house at the time of incident. It is also not disputed that PW6, the daughter of the accused, was also in the house at the time of the unfortunate incident under such circumstances. Under the PW6 in categorical terms supported the case of the prosecution by saying that it was the accused who was harassing the deceased, and on the date of incident, he strangulated her neck with a veil. There is absolutely no reason as to why her evidence is to be disbelieved. Her evidence is to be disbelieved.
They are not disputed the results. They are not offered explanation.
When the accused has not disputed his presence in the scene of occurrence, that is in his house at the time of incident, it is the burden will, when the prosecution is successful in placing cogent materials to prove the guilt of the accused, the burden sits on the accused
Just to decide one of
to discharge his burden as provided in the section 106 of the Evidence Act. He said burden is not discharged by the accused. It is also one of the strongest circumstances which is against the accused. He further contended that the accused has admitted the incriminating material put to the accused in the statement under section 313 of CRPC. Under such circumstances, there is absolutely no reason to interfere with the impugned judgment of conviction and the order of sentence passed by the trial court, hence he pays for dismissal of the petition. In view of the rival contentions taken by the parties, the following points should arise for our consideration. Whether the trial court is justified in holding the accused guilty for the offense punishable under section 302 of IPC and in passing the impugned judgment of conviction and order of sentence dated terms. This court, being the appellate court, considered the entire materials on record, including the original trial court record. PW1 is the brother of the deceased who logged the such information after coming to know about the incident. This witness in his evidence categorically stated that the marriage of the accused was performed with the deceased about 17 years back, and the accused and the deceased were residing in the Tyagaraja Nagara at Bengaluru. They have begotten 2 daughters in their marriage. The accused was working in a shop in the market. About 10 years, they led happy married life. And thereafter, when they begotten 2 daughters, the accused started entreating the deceased as she had not given birth to a male child. There were panchayats in this regard. Witness stated that he had advised the accused several times, but still he continued his behavior and was ill-treating the deceased. Witness stated that on 22/3/2012, when he was in Kengeri, he received a phone call from his sister regarding the accused causing the death of the deceased Shivamma. Immediately, he rushed to the spot and found his sister Shivamma laying inside her house. A veil was tied to her neck and she had died. Immediately, he also stated that the accused had ran away from the scene of occurrence after committing the murder. Immediately, he lodged the first information as per Exhibit P1. Witness also stated that the police had drawn the spot measure as per Exhibit P2. Witness identified the veil used by the accused in commission of the offense as MO1. Witness specifically stated that the accused has caused the death of the deceased by strangulating her neck only with an intention to cause her death to enable him to marry for the second time. This witness was cross-examined by the counsel for the accused, only suggesting that the accused was not entreating the deceased and he had no motive for causing her death. All such suggestions were denied by the witness. PW2.
Nothing has been elicited.
There is nothing has been elicited from this witness to disprove his version. PW2 is a Mahazar witness to the spot Mahazar Exhibit P2. He fully supported the case of the prosecution. PW3 is the witness to the inquest Mahazar Exhibit P3. This witness has also supported the case of the prosecution with regard to the drawing of the inquest Mahazar. PW4 is a material witness, and she being the daughter of the accused, stated that till the birth of PW6, Shivani, the accused and the deceased were in cordial terms. When 2 daughters were born, the accused started mistreating the deceased. Since about 4 to 5 years, the accused used to pick up quarrel with the deceased. It was stated that on 22/3/2012, she had been to the school in the morning and returned at 4:30 p.m. Immediately, her sister Shivani informed her that their father had strangulated the neck of the deceased with a veil and caused her death. Her sister Shivani was weeping and informed the fact. Witness stated that immediately she rushed into the house and found her mother dead. The veil was tied to her neck. The blood was oozing from her ears. Witness stated that she was very much frightened and informed this fact to her aunt, CW11, who in turn informed PW1 over phone. Witness identified MO1, the veil used by the accused in commission of the offense. This witness was also cross-examined at length by the learned counsel for the accused, but nothing has been elicited to disbelieve his version, her version. PW5 Renuka is the sister of the deceased. This witness has also stated that the accused had married the deceased about 15 years back. Initially, they were in cordial terms. About 2 to 3 years prior to the incident, the accused started picking up quarrel with the deceased only for the reason that she had not begotten a son. Witness stated that she had advised the accused several times, but he had not heeded to the same. Witness also stated that about 2.5 years back, she came to know that the accused had caused the death of the deceased. Immediately she went to the spot and found Shivamma laying dead. The veil was tied to her neck. She tried to revive her, but it was in vain. Immediately she called PW1 and informed the facts. Witness stated that she had given a statement before the police that the accused has caused the death of the deceased. Witness identified MO1 veil as the same was used in commission of the offense. Nothing has been elicited from this witness to disbelieve her version. The material witness to the prosecution is PW6, the eyewitness to the incident. She is the daughter of the deceased and the accused and was aged 7 years when she was examined with the court. After satisfying with her capacity to depose with the court from her statement, evidence was recorded by the trial court. Witness stated that she was residing along with her father, mother, and sister. She identified the accused as her father and stated that he himself had caused the death of her mother. Witness stated that at the time of incident, her sister, that is PW4, had been to the school. The accused tied the veil to the neck of her mother and identified the said veil as MO1. Witness stated that she tried to sprinkle water on the face of her mother, but she had not got up. In the meantime, her sister, PW4, came to the house and that she informed her sister about the incident. Even though the witness was cross-examined by the learned counsel to the accused, nothing has been elicited to disbelieve her version. PW7 is the doctor who conducted postmortem examination on the dead body of the deceased. He noticed the 7 external injuries on the dead body and issued the postmortem report, Exhibit 3-4. The opinion expressed by the doctor for the cause of death as asphyxia as a result of strangulation. Nothing has been elicited from this witness during cross-examination, even though it is suggested that the deceased could have committed suicide by tying the veil. The same has been denied by the doctor, by the witness. Mine is the police constable who carried the material objects MOs 1 to 4 to RFSL for examination and brought the report as per Exhibit P7. PW10 is the brother-in-law of the deceased who spoke about the conduct of the accused in ill-treating the deceased for the reason that she had not begotten a son. Even though the witness is cross-examined by the learned counsel for the accused, nothing has been elicited to disbelieve his version. PW11 is the police constable. So 11 and 17 are the police constables who traced the accused and produced before the investigating officer. PW12 is the ASI who carried the FIR to the jurisdictional magistrate. PW13 is the sister of the deceased, and 14 is the employer of the deceased. Both these witnesses have not supported the case of the prosecution. PW15 is the police inspector who conducted the investigation. Witness stated that PW1 has filed the first information as per Exhibit P1 and he registered the FIR as per Exhibit P10. He has drawn the spot measure as per Exhibit P2 and the inquest measure as per Exhibit P3. Witness also stated that the accused has given the voluntary statement as per Exhibit P11 and he got the spot sketch drawn through PW16 as per Exhibit P12. He collected the postmortem report as per Exhibit P4 and identified MOs 1 to 4 as recovered from the spot. Witness further stated that after completing the investigation, he filed the charge sheet against the accused as there are sufficient materials to constitute the offense under Section 302 of IPC. Nothing has been elicited from the witness during cross-examination to disprove his version. PW16 is the assistant engineer who drawn the spot measure as per Exhibit P12. On the basis of these materials on record, the trial court proceeded to convict the accused for the offense punishable under Section 302 of IPC. We have given our thoughtful consideration to all these materials on record in the light of the rival contentions as before us. It is the specific contention of the prosecution that the accused is the husband of the deceased caused her death by tying the veil MO1 around her neck and strangulating. PW1, 4, 5, and 6 are the close relatives of the deceased and the accused have spoken regarding the conduct of the accused in picking up quarrels with the deceased frequently since about 4 or 5 years, only for the reason that she had begotten 2 daughters, but she had not begotten a son. Even though all these witnesses were cross-examined by the learned counsel for the accused, nothing has been elicited from them to disbelieve their version. PW1 and 5 categorically stated that several panchayats were held and they have advised the accused to mend his ways. But the accused has continued ill-treating the deceased, and on the fateful day, he strangulated her neck by tying the veil around her neck. PW6 is the star witness to the prosecution, who is examined as an eyewitness. The witness, even though a child witness aged 7 years, categorically stated that on the date that accused used to pick up quarrel with her mother, and on the date of incident, he strangulated her neck with the veil MO1, as a result of which her mother fell down. She tried to revive her by sprinkling water on her face, but she had not got up. In the meantime, her sister PW4 came to the house and she informed this fact to her sister. This version of PW6 is corroborated by PW4, who also stated on oath that when she returned from the school at 4:30 p.m., PW6 was reading and informed about the incident.
That enmity against the will of father.
Nothing has been elicited from PW6 to contend that PW6 had any motive or other reason to
Enmity.
depose enmity
Against her own father.
enmity against her own father to depose against him. It is also not the contention of the accused that PW6 is a reputed witness and that is why she deposed against him. Under such circumstances, we do not find yes, the conduct of PW6 as narrated by PW4 and 6 discloses that she is a natural witness who was in the house along with the deceased and the accused at the time of incident, and her conduct was also so natural as narrated by her. We do not find any reason to discard the evidence of these material witnesses, including PW6. Next, the contention of the prosecution that the accused caused the death of the deceased by strangulating her neck with the veil MO1 is supported by the evidence of PW7, who is the medical officer who conducted postmortem examination of the deceased and issued Exhibit P4. As per Exhibit P4, there were as many as 7 external injuries. That is exceptionally on page number 111 in the 111 and 114. Yes, the cause of death was due to asphyxia as a result of strangulation, and the witness stated that he has issued Exhibit P4. This opinion of the doctor who conducted postmortem examination is corroborating the contention of the prosecution and the evidence of the material witnesses discussed above.
But not possible.
Yes. It is pertinent to note that during cross-examination of PW7, a specific suggestion is made by the learned counsel for the accused that
Not possible.
suggested that the witness specifically stated that it is not a case of suicide, but a clear case of strangulation. We have no reason to disbelieve the version of this witness. The other witnesses referred to above are all circumstantial witnesses who have supported the case of the prosecution in their own way. Then the evidence of yes, yes. When the evidence of PW1, 4, 5 and PW6 along with the evidence of PW7 is taken into consideration, it is clear that the prosecution is successful in proving the guilt of the accused for the offense punishable under section 302 of IPC. When the accused has not disputed his presence at the scene of occurrence at the time of incident, the burden of proving it is his responsibility to offer a reasonable explanation for the unnatural death of his wife. The accused has not made any efforts in offering any explanation for the death of the deceased. In the absence of any reasonable explanation, offered by the accused, adverse inference will have to be drawn against the accused. Our, our finding is supported by the dictum of the Honorable Apex Court in Prahalad versus State of Rajasthan, 2019 at 14 SCC 438, wherein the Honorable Apex Court in Para 11 held as under 313 version. Para 11. It is also pertinent to note that the accused was examined under section 313 of CRPC before the trial court, putting all the incriminating materials available on record as spoken to by the prosecution witnesses. Strangely, the accused has admitted all those incriminating materials available on record. There is absolutely no reason to discard his admission in 313 statement recorded by the trial court.
Yes, but there are others. Apart from 313 statement, there are other.
Even though the statement of the accused, admission of the accused in a 313 statement cannot be the sole basis to convict the accused, the same is one of the circumstances in the chain of circumstances, along with the materials that are placed by the prosecution as discussed above. In view of the above, we are of the opinion that the prosecution is successful in proving the homicidal death of the deceased Shivamma by the accused as he strangulated her neck with the veil MO1 and thereby committed the offense punishable under section 302 of IPC. And the prosecution is successful in proving the guilt of the accused beyond reasonable doubt, the accused has not taken any specific defense nor probabilized the same. Under such circumstances, we are of the opinion that if the accused is liable to be convicted. Yes, we have gone through the impugned judgment. We have gone through the impugned judgment of conviction and order of sentence. Passed. Yes. And through the impugned judgment of conviction and order of sentence passed by the trial court, but reapprising the materials and records, we do not find any reason to interfere with the same. In view of the above, we answer the above point in the negative and proceed to pass the following. Criminal appeal is dismissed as devoid of merit. The judgment of conviction and order of sentence passed by the trial court in SC so and so, dated so and so, is confirmed. In view of the disposal of the criminal appeal, the interlocutory applications pending, if any, are disposed of. Would not survive for consideration.
Yes, come on, last matter. ಇದು ಮುಗಿತು ವೇದಾಂತ ವರ್ಷದ್ದಲ್ಲ ಇನ್ನದ 30 ಯಾವಾಗ ಬರ್ತಂತೆ ಪೇಪರ್ ಬುಕ್ ವೆರಿ ಗುಡ್ ಅದು ನಂಗೆ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಿ ಎಸ್ ಸರ್ ಕಮ್ ಆನ್ 302 only 302 all right ಕೊಡಿ Who is the accused? Who is the accused? He killed whom? In the jail. Wow, wonderful. When is the rowdy sheeter? The rowdy sheeter. You don't want to come back outside. Therefore, you want again kill another person in jail itself. You don't want to come out from the jail. Therefore, he killed one again inmates of the jail. That is complaint by jail superintendent. All the witnesses, jail witnesses. Natural witnesses. We'll continue tomorrow. A new case. The person in jail killed the other inmates in the jail. In the presence of all security. Yes. Yes. Siri Rajshekar. Siri. Mama. Case called thrice. So morning after arguing the matter of some time, after the request of Siri Rajshekar was passed out to get instruction to withdraw the contempt or to impose cost. No representation made. Call tomorrow.
Appear for in serial number 12, your lords. I apologize. Morning the matter was called out. I appear on behalf of Siddharth in this matter, your lords. Advocate Siddharth.
Mr. We are 12.1, not others.
Okay. I apologize.
Where is Shiri? No. Case called twice. The counsel for the complaint has no institutional responsibility. Thereby not appeared, even though matter passed over by thrice. To get instructions, withdraw or for imposition of cost. Nala bandilla andra details of ಜಾಸ್ತಿ ಬರೆಯೋದು ಮಿತಿಗಳ ಬಿಲ್ಡಿಂಗ್ ಅದು ಮಾತ್ರ ಹುಡುಗಿ ಎಷ್ಟು ಬೇಕಾದ್ರೆ ಅಂದ್ರೆ ಸುಮಾರು ನೋಡಿ ಸಿಂಗಲ್ ಹೇಳ್ಬಿಟ್ಟು ಸಜೆಷನ್ ನಾಳೆ ಬರ್ಲಿ ಏನು ಪಾಠ ಮಾಡ್ಬೇಕು ನಿಮ್ಮ ಮಕ್ಕಳಿಗೆ ಹೇಳ್ತೀನಿ
Code officer, sir. Sir. Sir, code officer, sir. Sir, serial number 12, Siddharth B. Muchendi.